Hi everyone, my name is Alexander Zalivakov, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would look today into the personal affiliation criteria and the way it is challenged in connection with the EU judicial review proceedings brought against the Council by the persons subject to EU asset-free sanctions. The reason why we look into this matter is that this seems to have been recently producing a line of case law where those elements of challenge are most successful. And the questions we would try to ask in the course of this presentation set out here, namely, what are the personal affiliation criteria? What makes them so distinct from other categories of criteria? And we would look into the three most common personal affiliation criteria employed by the Council when developing international economic sanctions, namely the associated person criteria, the family affiliation criteria, and the personal benefit criterion. And then we will try to reflect on how this is incorporated into the judicial review proceedings brought on the basis of any of those criteria being not satisfied. We would start by a short recap of how EU asset-free sanctions operate to bring this presentation into the general context. The asset-free sanctions are imposed by first decision of the Council made pursuant to the common and foreign and security policy. The decision is then implemented at the level of the European Union or at the level of EU member states, depending on whether the European Union or member states are competent to take relevant measures. And to the extent the measures are implemented at the level of the European Union, they will be typically so implemented pursuant to the powers granted in Article 215 of the Treaty on the Function of the European Union, and would include, among other measures, the asset-free sanctions imposed against the individuals. As the relevant measures are imposed at the level of the European Union, the relevant judicial review proceedings need also to be issued at the level of the European Union, and the right to issue the relevant proceedings is found in Article 263, which allows the person to challenge directly applicable individual sanctions, which will include asset-free sanctions. Important point is that given the substantial restrictions on human rights of the relevant individuals which arise in connection with targeted financial economic sanctions, and more specifically with asset-free sanctions being the most restrictive measures available in sanctions arsenal, the way the sanctions are imposed requires that a certain predefined criteria for the introduction of sanctions are included in the regulations. This criteria will set out the categories of persons which are believed to be involved in one way or another into the activity which the European Union wants to change by way of financial sanctions. Among those criteria, and this is the subject of our today's discussion, there are criteria which are based on personal affiliation with the involved persons, namely that the relevant sanctioned person is not directly in his own name and in his own capacity involved into the actions which the sanctions purport to change, but he has some sort of affiliation with an involved person. And those are mainly three categories of affiliations, which are used in the EU sanction program: so-called associated person criteria, personal benefit criteria, or family affiliation criteria. This makes these criteria specifically problematic and subject to challenge. And we would look now into how this developed in the jurisprudence of the European courts. We start by the associated person criteria, which is a known concept used in various EU sanctioning programs. Here, by way of example, to demonstrate how the criteria operates, I picked up now repealed regulation which introduced the EU sanctions program against Burma at the relevant time. And we can see here that the asset-free sanctions may be imposed against the members of the government of Burma, which was believed to be responsible for various human rights violations and other acts which the EU want to remedy occurring in the country, but then natural and legal persons associated with the government of Burma. So the important point to start is to appreciate that there is no requirement in the application of this criteria that an associated person is directly involved into, for example, human rights violations in Burma. A mere level of association with the government of Burma is sufficient. And that resulted, for example, in the designation of Paifio Taidza on the relevant sanctions list. At the time of the designation, he was 13 years old, living with his mother for a substantial period of time outside of Burma. He was living in Singapore. He was a student. And from that perspective, a question arose whether he indeed satisfied the association criteria, because he was not even directly associated with the government of Burma, but in effect his father, Taidza, was one of the leading Burmese businessmen. And the association which he challenged in the judicial review proceedings was in essence based on the point that other than being the son of his father and having some joint participation in the companies outside of Burma with no relation to the political regime, he did not meet the association criteria. The court reviewed 2 points in the relevant judicial proceedings. First, whether criteria is such, is legitimate, where the response in essence was given that given the substantial discretion which has to be granted to the council in terms of developing criteria for the designation of the persons within the sanctions program, the criteria is legitimate. And whether this criteria was satisfied with the facts of the given case, the analysis of the case permits us to conclude that the key point in finding that the criteria was satisfied was the common shareholding in certain companies located outside of Burma, and presumably the funds which were received from the father to acquire those shareholdings. The associated person criteria is very commonly used in drafting EU sanctions programs. And for that reason, it's subject to various clarifications given by the courts in the course of judicial review proceedings. And most recently, in the context of the EU sanctions program against Russia, there were multiple designations and multiple proceedings issued on the basis of these criteria, which allowed to further clarify the scope of its application, where in essence, one can state today that any type of common interests would be sufficient to meet the associated person criteria. to the extent that those common interests extend over a family relationship. It's not sufficiently clear whether what the council or the courts may consider to be abnormal support within family members will be based on the exclusivity of family relationship covered. But what seems to be clear is that to the extent there is a business relationship, the relationship which is not related directly to family matters, this would suffice to meet the associated person criteria. Important point to note is that the courts qualify this criteria in time. The associated person criteria needs to be satisfied at minimum as of the moment when the person was designated. So to the extent we talk about anything which happened before the designation, and certainly the longer the period of time has passed since the relevant commonality of interest was established and the designation was made, the more likely the criteria would not be satisfied. So, for example, going back to my example, whether some extraordinary funding of one family member or another family member would fall within exclusivity of family relationship and would be deemed to go over that relationship, the answer remains uncertain. But what is certain that to the extent those benefits were accorded before the designation occurred, and the longer the period of time, the less relevant those benefits would be, then the criteria should not be deemed to be satisfied. Another family affiliation criteria is found in the Syrian sanctions program, which is a rare example of a situation when the family affiliation was sufficient for the purpose of designation. So the criteria for the designation, the Syrian sanction program allowed the council to designate any member of Assad or Maklouf families. No additional requirements in terms of participation in the reprehensible behavior or any matters related to the political process in Syria were required. So it's an example of a situation when the sole member, personal affiliation with the relevant family may suffice. The justification for using this criteria in the relevant regulation was some specific features of how the political life and structure of society is organized in Syria, where family allegiance plays a very important role. Nevertheless, it's important to note that even with respect to this criteria, a carve-out was included in the relevant regulation, which in essence allowed the member of the family to argue that he or she shall not be designated solely by virtue of being the member of a Assad or Maklouf families, if this member of the family demonstrated that he broke any type of relationship with the Syrian regime at the relevant time, and that there is no risk of the circumvention of the sanctions. The court had an opportunity to discuss these criteria in the context of various judicial review proceedings brought by the members of the Maklouf family, where in essence the court approved the criteria as such. But it's important to note that in the context of that approval, the court gave substantial weight to the possibility of the relevant person dissociate herself or himself with the regime and prove no circumvention. And it seems that this opportunity was an important matter in terms of legitimizing the criteria itself. So, for example, in the case of Sarah Maklouf, the relevant absence of dissociation was found in the fact that Ms. Maklouf accepted the estate of her father, prominent politician in the Syrian regime, and for that reason, in effect, did not prove that she sufficiently dissociated herself from the behavior which the European sanctions purported to address. The last in the set of personal benefit criteria is the personal benefit actually itself, which was introduced in the Russian sanctions regulations. Article 3.1 subparagraph G sets out that the immediate family members or other natural persons who benefit from leading Russian businessmen may be designated. What we need to acknowledge is that at its face value, the criteria is extremely broad. Reference to any other natural person means that any service provider, for example, legal consultant, who deals with a leading Russian businessman, may in principle be designated. So it's a very broad criteria, and it's not surprising that when considering the designations made on this basis, the courts have imposed substantial restrictions on how the criteria may be employed, and more specifically declared, among other restrictions, that a normal business relationship, whereby a person provides services, for example, in exchange for a market consideration for those services, shall not be sufficient to bring this person within the relevant category of persons who are subject to the risks of the designation. The court further set out that the cutoff date for the application of the benefiting criteria will be February 2014. And it's important to look to other points, more specifically whether the relevant direction give to the issues of circumvention of the relevant sanctions regime when deciding whether this criteria is satisfied. Now we would think how these overall criteria fit into the general judicial review proceedings brought on the basis of any of them. The starting point to acknowledge is that the courts seem to be hesitant in terms of accepting designations based on family or business or other type of personal affiliation between a listed person and a third-party individual, in the circumstances when that third-party individual herself or himself is not directly involved in any type of reprehensible behavior with sanctions purport to correct. And that's, to a certain extent, is obvious. The link between the behavior which the sanctions purport to correct is even less clear. And for that reason, the courts require, whilst in principle accepting that these designations are permitted, require something more than personal or normal arm's length business relationship is present for the designation to be effective. More importantly, in the circumstances brought under these designation criteria, the European courts engaged in a very detailed analysis of reviewing the evidence which was brought by the Council to justify the inclusion. The Council has to justify the inclusion. It's the burden which rests with the Council. And the courts do not give substantial discretion to the Council on how the Council interprets the benefit, the evidence, which was used for the purpose of designation. So the courts will really question the reliability of the evidence, and whilst in principle the Council would have the flexibility in terms of the sources the Council can employ. So, for example, typically these designations will be made on the basis of various press articles or internet articles, and the courts will not exclude them per se from the proceedings, but the court will really wish to understand for themselves if there is really the connection between the information provided in those articles and the relevant benefit or common interests which were found in this specific case. In terms of the criteria, the associated person criteria seems to be particularly broad. It's been used for many EU sanctions program. So there is substantial case law which sets its limits, and so far it seems that any type of commonality of interest will be required, and the only point which remains clear is that this commonality of interest shall go over normal family relationship. Having said this, there is an important timing point, which is that the commonality of interest shall exist at least at the time of the designation, and arguably shall continue throughout the process when the Council reviews the relevant designations made. So to the extent the commonality of interest between the designated persons would fall outside normal family relationship, it seems to be open for such persons to dissociate themselves in terms of cutting the link which was used by the Council to designate them, and this should allow the successful application for the judicial review of the relevant designation matter. The benefit criteria is more complex and more restricted in terms of its application. The courts require that the benefiting person take some kind of advantage from the person who provided to him the benefit. And to the extent this advantage cannot be demonstrated, and the courts will review the evidence closely, then the relevant application has good chances to succeed. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next presentations.